When people come into Connecticut divorce court for the first time, one of the most common mistakes I see is someone trying to tell the judge what someone else said, and being genuinely surprised when the judge stops them mid-sentence. That usually leads to a quick explanation from the court. What you're trying to say is hearsay. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I want to talk about hearsay in the context of a Connecticut divorce hearing or trial. What it is, why it matters, and some of the situations where it actually is allowed. Now, at its most basic level, hearsay is an out-of-court statement that's being offered in court to prove that what was said is true. In real life, that often sounds like, my sister told me my husband is hiding money, or my child's teacher said my daughter is anxious when she goes to her mother's house, or my neighbor said my spouse has someone staying over overnight. In all of these situations, the person who actually made the statement isn't in court, isn't under oath, and can't be cross-examined. That's the core reason hearsay is generally not allowed. Now, judges care deeply about reliability. If someone isn't in the courtroom testifying, the judge has no way to assess their credibility, their honesty, or the context in which the statement was made. That's why, as a general rule, hearsay is excluded in Connecticut divorce cases just like in any other court proceeding. Now, this becomes especially important because hearsay issues come up constantly in divorce litigation. Parents often want to testify about what a child said. Spouses repeat things they heard from friends, relatives, or even professionals. People try to introduce emails, texts, or financial information without laying a proper foundation. When this happens, judges will often stop the testimony immediately. With that said, not all hearsay is automatically excluded. Connecticut follows the Connecticut Code of Evidence, and there are exceptions that come up frequently in divorce and family court matters. Understanding those exceptions can make a critical difference in whether the judge is able to hear important information in your case. One of the most common exceptions involves statement made by a party opponent. If your spouse said something to you in the past and you're testifying about it, that statement should be admissible. For example, if your husband told you he was being paid in cash so the income wouldn't show up on his taxes, that statement should be allowed because it came from a party opponent. Another exception that plays a major role in divorce cases involves business records. Financial documents like bank statements, credit card records, payroll records, and tax returns are often admissible even though they contain statements made outside of court. These records usually come in under the business records exception as long as they're properly authenticated, and they're often the backbone of financial evidence in a divorce trial. There are also situations involving medical or mental health treatment where statements made for purposes of diagnosis or treatment may be admissible. This can arise in custody cases that involve therapy, substance abuse, or mental health concerns, although those issues are often closely scrutinized and contested. One area that causes a lot of confusion and emotion involves statements made by children. In most cases, a parent cannot testify about what a child said in order to prove the truth of that statement. Connecticut courts are very careful about protecting children from being placed in the middle of divorce litigation. When a child's views or experiences are relevant, the court typically relies on a guardian ad litem or a court-appointed family relations evaluator to relay the child's statements rather than relying on parental testimony that amounts to hearsay or having the child testify in open court. There is also what's known as the residual or catch-all hearsay exception, and this is one that people often misunderstand. Just because a statement doesn't fit neatly into one of the listed exceptions doesn't mean it won't come into evidence. In Connecticut, the court can admit hearsay under the residual exception if the statement has strong guarantees of trustworthiness, is highly probative, and if admitting it serves the interests of justice. In family court, judges may occasionally rely on this exception, especially in situations involving statements of children or unusual circumstances. Courts apply it cautiously, and relying on it without a solid evidentiary foundation is risky. All of this matters because if your case relies heavily on hearsay and there isn't a valid exception, the judge may never hear some of the points you believe are most important. I've seen cases where someone has legitimate concerns and real issues, but because the evidence was presented improperly, it was excluded entirely. So if you're facing a contested divorce hearing or trial in Connecticut and want help understanding how evidence is actually handled in court, or you're looking for representation in a family law case here in Connecticut, we would invite you to contact our office.